Hello everyone, my name is Gabriela Machado and I'm here today with Marcelo Lapolla, a partner of VezziLapolla, the Brazilian member of latam.legal, to talk about arbitration in Brazil and the international landscape. Hi Marcelo.
Hi Gabriela, thank you for the invitation. It's a pleasure to talk to you and to latam.legal network.
So why do you think arbitration's grown so much as a method for resolving commercial disputes in the last few decades?
I would say arbitration has grown for a very practical reason. Businesses need dispute resolution that matches the complexity of modern commercial relationships. When you're dealing with a joint venture, a construction project, or an M&A dispute, you want decision makers who actually understand the industry, not just legal principles in the abstract. That is the first driver, the technical expertise. The second is confidentiality. Companies don't want their internal disagreements, their numbers, or their strategic decisions exposed in open records, especially when a competitor could be reading them. And third, arbitration gives parties control over the calendar. You're not waiting in a queue behind hundreds of other cases. You agree on a timeline with a tribunal, which brings a level of predictability litigation rarely offers. And finally, there's also enforceability. Thanks to the New York Convention of 1958, an arbitration award can be recognized and enforced in more than 170 countries. That's a reach no domestic court judgment can match. Put those four things together: expertise, confidentiality, procedural control, and international enforceability, and it's easy to see why arbitration became the default mechanism for serious cross-border and high-value domestic disputes.
Yeah, absolutely. It makes completely sense. Before we compare Brazil internationally, let's set the stage. How has arbitration evolved domestically since the 1996 Arbitration Act? And what role do Brazilian chambers play today?
Gabi, before 1996, arbitration in Brazil existed on paper but rarely functioned in practice. And arbitral decisions still needed judicial homologation before it had any real force, which defeated much of its purpose. The Arbitration Act, Law 9307, changed that completely. It gave arbitral awards the same enforceability as a judicial title without prior court approval. That was the real turning point. Further, the Supreme Court then confirmed the law's constitutionality in 2001, which removed any uncertainty for businesses considering arbitration clauses. From there, we saw a maturing ecosystem, particularly in commercial and credit-related contracts and intellectual property disputes. A further reform in 2015 extended arbitration to public administration contracts and clarified its use in corporate disputes such as shareholders' disagreements and exclusion of partners. Today, Brazilian chambers aren't just a domestic alternative to litigation. They are increasingly seen as credible venues even for disputes involving foreign parties with connection to Brazil.
So what independence and conflict of interest standards do arbitrators need to meet in the region?
Independence is really the currency of legitimacy in arbitration. Without it, none of the other advantages matter. In Brazil, the main chambers now require arbitrators to sign a detailed disclosure statement before accepting an appointment, listing any prior relationships with the parties, their counsel, or related companies, going well beyond a simple checkbox. The IBA guidelines on conflict of interest, while not binding law, have become the de facto reference point most Brazilian and Latin American chambers use to classify relationships into red, orange, and green lists, helping parties and arbitrations alike gauge what needs to be disclosed and what's generally disqualifying. The continuing duty to disclose also matters just as much as the initial statement. If a conflict arises mid-proceeding, arbitrators are expected to flag it immediately and not to be challenged. The system isn't perfect, of course, but in a region where the pool of experienced arbitrators is still relatively concentrated, Repeated appointments between the same professionals and the same law firms happen more often than the ideal. And that's precisely why chamber level scrutiny and party vigilance both matter. Ultimately, an arbitral award is only as strong as the impartiality. So this is an area that deserves as much attention as the substantive law itself.
Yeah, that makes complete sense. I think ethics play a huge role in arbitration worldwide. Now, how does Brazil compare to the major international arbitration hubs such as London, Paris, Singapore, and New York?
I would say that Brazil has come a long way, but it's important to be honest about where the gaps remain. On the positive side, our Superior Court of Justice has taken consistently pro-arbitration stance, respecting the tribunal's jurisdiction and rarely interfering. That predictability matters enormously to foreign investors. Where international hubs still have an edge is institutional maturity. The ICC has been operating since 1923, the LCIA since 1892. That's a century of case law, procedural refinement, and a truly global pool of arbitrators who move comfortably between jurisdictions. Singapore, in particularly, built its reputation deliberately, world-class infrastructure, a neutral geographic position for Asian disputes, and government-backed investment in becoming a dispute resolution hub. Brazil's remaining friction points are more about the surrounding judicial ecosystem than arbitration itself. The time it takes to get interim measures from local courts in support of a tribunal, for example, or overall cost predictability compared to more established markets. So the honest comparison is this: Brazil is fully credible as an arbitration seat today, especially for disputes with a strong domestic nexus. But for pure cross-border disputes between parties with no connection to Brazil, London, Paris, and Singapore still have the deeper institutional track record.
Yeah, I understand that. And given that comparison, when does it actually make sense for parties to choose an international seat instead of Brazil?
Well, Gabi, I would say it comes down to connection and neutrality. If neither party has a meaningful tie to Brazil, say a Colombia company contracting with a company in the US, there's little reason to anchor the arbitration here. Neutrality is the whole point. Neither party wants to arbitrate in the other side's backyard. Asset allocation matters too. If the counterparty's assets sit entirely outside Brazil, it often makes more sense to obtain an award that's immediately enforceable where those assets actually are, rather than adding an extra layer, which would be the homologation before the Superior Court of Justice, before you can even start collection. Institutional track record is another factor. When a dispute is highly technical and extremely high value, parties sometimes prefer the ICC, the LCIA, or the ICDR simply because there's a longer history of similar cases and a broader roster of specialized arbitrators to draw from. The trade-off, of course, is cost. International institutions are considerably more expensive than Brazilian chambers. So the decision is a balance between the premium you pay for institutional depth and neutrality versus the efficiency and lower cost of a well-relegated domestic chamber when the dispute has a real connection to Brazil.
You mentioned enforcement, and I think that's really interesting. So let's talk about it. How does the enforcement of arbitral awards actually work in Brazil, both domestic and foreign?
Mm-hmm. There's an important distinction here, and it's one that surprises people outside the field. A domestic arbitral award in Brazil is already an enforceable judicial title under our code, our civil procedure code. It has the same standing as a final court judgment. There's no need for prior homologation. You go straight to enforcement proceedings if the losing party doesn't comply voluntarily. Whereas a foreign award is different. It first needs to be recognized, homologated by the Superior Court of Justice based on the New York Convention of 1958, which Brazil ratified in 2002. So in practice, the court's posture has been very favorable to recognition. Refusal is the exception, generally limited to issues like violation of public policy, a lack of due process, or a tribunal that clearly exceeded its jurisdiction. But the practical challenges aren't really legal, they are operational. The homologation process takes time, and once you have your enforceable title, locating and attaching the debtor assets in Brazil can be its own battle. That said, the broader signal is clear. Brazil is widely regarded internationally as an arbitration-friendly jurisdiction, and that reputation is itself a factor for foreign investors to weigh when deciding where to do business.
Okay, and which sectors are relying most on arbitration in Latin America today?
Well, in Latin America, I would go for corporate disputes that are probably the most consistent source of arbitration work. Disagreements between shareholders, exclusion of partner, valuation disputes tied to put and call options. These cases often involve complex financial modeling, which is exactly the kind of technical dispute arbitration handles well. Mergers and acquisitions is another major area, earn-out disputes, breaches of representations and warranties, and post-closing adjustments. These contracts are drafted with arbitration clauses almost by default. And then there's also energy and infrastructure. They generate significant volume too, particularly disputes arising from concession agreements, EPC contracts, and project finance structures, sectors where technical complexity and long contractual duration make specialized tribunals essential. Finally, construction and engineering disputes remain a steady category, mostly around delays and contract amendments. And one trend worth watching, I would go for agribusiness and commodities. Given how much of Latin America economy runs on that sector, we're seeing a real increase in arbitration clauses in supply and trading contracts, which I expect to keep growing.
All of the subjects you mentioned are very technical, so it makes sense to bring the issue to an arbitration chamber. How has the technology and online dispute resolution changed arbitration since the pandemic?
Certainly virtual hearings went from being the exception to being the standard procedure, at least for procedural stages and even for some witness examinations as well. That shift alone cut costs and travel time significantly, which matters a lot for Latin American parties operating on higher budgets than counterparts in Europe. And case management platforms have also become far more sophisticated, document sharing, scheduling, evidence organization, all of which increasing efficiently reduces the administrative burden on both the council and the tribunals. And most institutions have now formally incorporated electronic procedures into their rules. So this isn't an improvised adaptation anymore. It's built into how modern arbitration operates. The one area I would say that still requires a real vigilance is information security. When a dispute involves trade secrets or sensitive financial data, moving everything into digital environment raises legitimate confidentiality concerns, and institutions need to keep investing in that infrastructure as much as they invest in convenience.
Yeah, cybersecurity is an issue worldwide as well. Let's talk a bit about our host today. So how and what role does latam.legal play in the regional integration of cross-border dispute?
latam.legal exists precisely because cross-border disputes in this region rarely fit neatly into one jurisdiction. When a dispute involves parties or assets in more than one Latin American country, having a network of firms that already work together, rather than assembling separate local counsel from scratch each time, makes a real difference in speed and coordination. We've also worked on standardizing contract language and procedural approaches across member firms, which pays off specifically at the enforcement stage, when everyone involved understands the same terminology and structure. Cross-border execution of an award moves faster and with fewer surprises. For foreign investors, the network offers a single point of contact with real regional reach instead of needing to vet and coordinate separate firms in each country. That's increasingly what sophisticated clients expect, and it's a big part of why we've invested in growing the network, including initiatives like a trilateral arbitration center connecting Brazil, Colombia, and the US, which reflects exactly the kind of cross-border dialogue this region needs more of.
And finally, to finish our session, because if not, we're going to stay here the whole day talking about it. What advice would you give companies drafting arbitration clauses today to avoid disputes down the road?
If I had to give one piece of advice, it would be this: don't treat the arbitration clause as boilerplate. It's often the last thing negotiated and the first thing that gets challenged when a dispute actually happens. So start with the basics, but get them right. Name the institution precisely, define the seat, the language, the number of arbitrators. Ambiguity in any of these can trigger months of preliminary disputes before the tribunal even gets to the merits. So think ahead about enforcement. If you expect the counterparty's asset to sit in a particular jurisdiction, that should inform your choice of seat and institution, since it affects how smoothly you'll be able to enforce an eventual award. So match the mechanism to the relationship. For a long-term contract, a joint venture, a supply agreement, consider tiered clauses that require negotiation or mediation before arbitration, that preserves the relationship and filters out disputes that do not need a full tribunal. And finally, review the clause periodically, especially in long-term contracts. Institutions update their rules, the legal landscape shifts, and a clause drafted a decade ago may no longer reflect what you choose today. So a well-drafted arbitration clause is cheap insurance, and a poorly one is often the most expensive line in the whole contract.
Thank you, Marcelo. Thank you for being here today. And thank you for watching us.
A pleasure.